Okay, here's the agreement. We want it signed within a few working days. Otherwise, it will be withdrawn. This is a really common tactic used, and don't be swayed by it, at all. It's because they want you to sign that agreement very quickly. Okay, so my name's Anita Kalra from Kalra Legal Group. I'm an employment solicitor, and I'm going to talk to you today about settlement agreements and how to negotiate a better deal. So you may be watching this video today because you've been offered a settlement agreement, or the relationship between you and your employer has broken down and you're looking to leave amicably, which is one way of being able to do that is via a settlement agreement. Or you're watching this video because you want to be offered a settlement agreement, but you're not there yet. Another reason why settlement agreements are used is if an employee's raised a grievance, or if the employer is going through a redundancy situation, then settlement agreements are also utilised in that situation. So what is a settlement agreement? A settlement agreement effectively sets out the terms of the exit between the employee and the employer. Within that agreement, you will be effectively waiving any potential claims you may have in the employment tribunal. So if you have a claim for unfair dismissal, by signing a settlement agreement, normally you'd be waiving that claim. And similarly in a situation, if you've got any bonus disputes, any unlawful deduction of wages disputes, any type of claim effectively that would be chaired in an employment tribunal, you'd be effectively waiving your right to be able to bring that forward to an employment tribunal by then signing a settlement agreement. So that's why settlement agreements are utilised. Now, they are very beneficial as well for an employee, and some of the benefits by going through a settlement agreement allows you to negotiate your terms when you're exiting the company, and I'll go through those with you now. So if you're offered a settlement agreement, you are normally offered up to 7 working days to go and speak to a solicitor and seek advice. Now, it's quite important that when you're offered a settlement agreement, you don't let it sit in your inbox for a few days before searching to speak to a solicitor, because it will take you time to find a solicitor that is available, and it normally takes at least 1 working day in terms of them being able to sign you up as well. So do go out and find a solicitor that can go through the settlement agreement terms with you. The next thing I would then do is go through your settlement agreement in advance of speaking to the solicitor, and make sure you familiarise yourself with the terms before you speak to the solicitor as well. Now, in terms of booking a call to speak to a solicitor, that call or that advice is normally covered by the employer. So they will make a contribution towards legal fees. That normally starts off at £250 plus VAT, and it can go up to £1,000 depending on what the terms are. But the standard contribution in most settlement agreements is anything between £450 and £500 plus VAT. Now, if you're looking to negotiate the terms of your settlement, your exit, so you're effectively trying to get a better deal, then it's very unlikely that the solicitor will be able to stay within that contribution. So they may offer you an hourly rate option or no win, no fee, in which case any additional amount negotiated, it would be on a no win, no fee basis. So they'd only take their fees if they're successful, which is great incentive as well for the solicitor dealing with the matter. But they'll also offer you an hourly rate option as well if that's more suitable. So keep that in mind, that actually if you're looking to negotiate a better deal, then it's very likely that the fees will go over the contribution that the employer is making. Another thing, though, that the solicitor can do is look to increase the legal fee contribution, and a lot of solicitors would do this as well. So actually, if they find that it's likely to take them more than a couple of hours and it doesn't cover the contribution, then they will look to try and cover the fees as well by requesting an increase in the contribution. Now, what will a solicitor do? So when you then reach out to speak to a solicitor, they will go through the settlement agreement terms with you and look to see whether or not you've been offered the correct package. So if it's a redundancy situation, they will work out the figures with you, they'll work out the notice pay, and the ex gratia payment. Now, ways in which you can negotiate a better deal. There are ways in which you can do this. So, of course, if you've raised a grievance or any complaints with your employer, and this is the reason why you've been offered a settlement agreement, then a useful way is to set out in writing what your potential claims are or your complaints are, and the value that you're seeking. Now, it is better to do this through your solicitor because they are also trained negotiators. But if you decide to do this yourself, then you would need to send this in a letter or in an email on a without prejudice basis, setting out exactly why you say you should be offered more money. And this could be for various reasons. It could be that it's likely to take you more than 6 months or 6 months to secure another role in the same sector. It could be that actually you need a period of time to recover from the treatment that you received from your employer. Or it could actually be that the restrictive covenants are so restrictive that actually you won't be able to secure another job for 6 months. So there could be a number of reasons, but I would set those out in writing and wait for the employer to respond. Now, normally they'll come back to you quite quickly if they're looking to negotiate the terms and reach an amicable exit. But you're looking at a couple of days before they respond, depending on how much you're asking for as well. If it's a lot more, then they most probably need to reach out to their own legal team. Now, who would you send this to? You would normally send this to HR, or if it's a small company, then the owner of the business. But normally it would go to HR in the first instance, and HR will then come back to you. Now, a very common tactic used by HR is that they will send you the agreement and they will say to you, okay, here's the agreement. We want it signed within a few working days. Otherwise, it will be withdrawn. This is a really common tactic used, and don't be swayed by it, at all. It's because they want you to sign that agreement very quickly. Of course, because it's going to protect them as a company, but also they don't want to pay you anything more. So by you taking your time or, taking a week to come back to them, leaves them at risk. So they will try and push you into signing an agreement very quickly. And it will be the role of your solicitor to go back and ask for more time. Or if you're negotiating this yourself, then I would go back and request more time. Because actually decisions can't be reached overnight. That's a very unreasonable expectation. But I have seen this happen where HR will come back and say, okay, here's the agreement, and it's 5 p.m. and they want you to sign it the next day. Now, in terms of what to look at in the agreement, so a couple of things that you can request. So if you're getting an exit package and the ex gratia payment or the compensatory payment is more than 30,000, you can get up to 30,000 tax-free. So that's one thing I would make sure you include within the agreement, that the first 30,000 of the ex gratia or the compensatory payment is tax-free. Now, pile-in payments, holiday payments are all taxable. So, you won't be able to get those tax-free. They're all taxable payments. Another things that you can request is you can request a reference. So you could negotiate the terms of your reference and include that in the settlement agreement. You could go away and write your own reference and send it to HR and see if they'd be happy to negotiate those terms. They may come back to you with some amendments, but that's a good way of negotiating your own reference in advance. Another thing I would look out for when you're offered a settlement agreement is the restrictions. So sometimes what an employer will do, which is quite very clever of them, is they will introduce new restrictions, so new restrictive covenants into your settlement agreement. So if it actually materialises that actually your contract of employment had no restrictions, they will insert them into the settlement agreement. So, I would be very careful into entering into any new restrictions, and make sure you seek advice from a solicitor. Now, if you've got any other questions, I would head to our website. We have a page dedicated to settlement agreements where we answer the most common questions. And the website is www.klglaw.co.uk. And I hope you found that video informative. Thank you.